Hi, this is Patrick Conroy, and this is Chapter 7, Interviews and Investigation in Civil Litigation. Before we get started, let's set the stage a bit. Okay, there's a couple things going on in this interview. One, you want to make sure that the client feels comfortable and also feels as if, this is a good place to take their case, that it's professional, that you listen, and that it's worthy of their money. So you have to be professional. The other side is the lawyer you're working for wants you to gather enough information to see if this case is worth their time. A big thing that you have to be careful of, if sometimes the lawyer does the initial interview with the paralegal present, or sometimes, you might just leave it to the paralegal to do. One thing you, as the paralegal, need to be sure of is you don't give any legal advice, because it's unauthorized practice of law. And we already talked about how you can get in trouble for that. So if it's just you are gathering information, period. So our learning objectives are to explain the importance of the initial contact with clients and witnesses, explain the considerations and steps in preparing for an interview of any client or witness, describe the skills needed to successfully conduct a client or witness interview, explain how expert witnesses are used in litigation, and explain the steps in conducting an investigation of a claim. Okay, the importance of the initial contact with client and witnesses. Any contact that a paralegal has with the client, prospective client, or witness constitute an interview. That's just the term for all of them. The paralegal is usually the firm's first point of contact with the new client or witness. Paralegals may conduct interviews on their own without the supervising attorney being present. Okay, this is the initial contact is called the screening interview. You're screening this as whether this is a good case for your attorney to take on. So limited first contact with prospective client may create an implied attorney-client relationship even though no fee has been yet paid. So you have to be careful that you do not offer any legal advice. And you make it clear that you are a paralegal and you are not authorized to practice law, and your whole purpose is to gather information. Letters of engagement and termination of engagement sets out the duties the law firm is undertaking for the client, basis of fees and terms of payment, and clarifies special costs such as depositions and investigation costs. So this is the kind of information you can give the client without giving legal advice, because you're not applying their facts to the law. You're just saying how the arrangement is, how the relationship breaks down cost-wise. Now, this is a sample contingent fee engagement letter. Now, as we said, contingent fees are often used in personal injury suits where the attorney is going to get a part of the money from the settlement or from the judgment. And this is just a form letter, basically laying it out, and I'm sure you can't read it. Explain the considerations and steps in preparing for an interview of any client or witness. Okay, so here we have a sample client interview checklist. This is something that's very useful to have because what it basically is the information you need to gather. And this is just sort of basic personal, contact information, birth dates, things like that. This would be for an auto accident. It reminds you that you have to gather certain things so the lawyer doesn't come back later and says, hey, was there any passengers in the car? And you're like, oh, I forgot to ask. This is a witness information form. You just fill it out with the witness there. You are just gathering information. Okay, preparing for the interview. The physical surroundings. You want them to be something that would make the person feel at home, but also to take in sort of the seriousness of the situation and the professionalism of you and your law firm. Okay, the impression a paralegal makes when walking into a room for the initial interview may set the tone for the entire relationship with the client or witness, and either can enhance or destroy one's credibility. Dress nicely. Dress nicely. You don't have to look like you're going in, into a gala. You don't need to look like Meghan Markle. You just have to look professional and clean, and that you take your job seriously. Okay, you need some communication skills, especially in a multicultural society. And you should be aware of cultural differences. Try not to step on any toes. Don't stereotype. Practice cultural sensitivity. I think most people in community colleges kind of have sensitivity to this as already, and it's also the age of the students. But you also cover this in business communication, which is why we require that as part of your degree, and in communications. Okay, the skills needed to successfully conduct a client or witness interview. Listening skills. Empathize. Do not interrupt. Don't become emotional. Avoid distractions like getting up and out of the room. Do not argue in your mind. You are just taking the information in. Do not antagonize and avoid jumping to conclusions. Your goal is for them to talk, not for you to talk. Ask open-ended questions. Open-ended questions are questions that usually don't have a yes or no answer, but call for a short narrative response. So instead of it being like multiple choice or true or false, it would be more like short answer or essay. Privileged communications. Okay, this is where you have confidentiality. You cannot go tell other people what you've discussed, just the attorney or anyone assigned to that particular case. We'll come back to do expert witnesses.